If I might, is there anybody else who'd care to speak at this point? If not, I'll call on my colleague Matthew Feher, an attorney with Burns and Levinson, based these days out of our Boston office, which I refer to as our back shop in Boston for our activities here. But Matt has practiced for a number of years in dealing with public finance and also public-private partnerships. Prior to that, he worked as a lobbyist for an association of municipal governments in Massachusetts as a lobbyist in the State House, and I'm sure he'll tell you about his other experiences as well. But this is intended to be an overview of the current legal authority in Rhode Island, both at the state level, excuse me, the quasi-public level, if you will, with quasi-public state agencies, and also the municipal level in terms of how they can approach, what authority they have to approach P3s. Matthew?
Thank you, Mr. Chairman. And through you to the members, thank you very much for having me today. I'm pleased to be here to discuss the legal framework here in Rhode Island in the area of P3. But before I do, I just want to thank all of you for your time and energy expended to advance possibly public-private partnerships as a tool here in Rhode Island, and happy to be a part of the conversation today and as you study the issue further. At the last meeting in November, we had a esteemed panel of gentlemen from various organizations that came in to discuss the types of P3s, what a P3 is, what it's not, how they work, the various structures, and so on. Bottom line, just for, again, everyone's edification, a P3 is a contractual arrangement between a public agency and a private sector entity, whereby the skills and asset of each sector are shared in delivering a service or a facility for the use of the general public. These structures do provide public awarding authorities, state, federal, and local, with opportunities to address growing infrastructure needs with new and innovative resources, including using private financing, equity financing, and the like. But one point to emphasize here, and it comes up all the time, as Sean mentioned, I'm based in Massachusetts, although I've practiced down here in Rhode Island and New York and in other jurisdictions doing P3 projects. And one of the things we encounter time and time again is that this is privatization. It could not be further from the truth. It is not the asset that's being transferred. The complete control of the asset is vested with the public agency. The project delivery, whether it's design, build, operate, maintain, and or finance, is what's being contracted to with the private entity. So I just want to be very clear about that, because it comes up all the time on Beacon Hill. It comes up all the time here in Providence, and it comes up in other state capitals. I've been looking at this issue for some time as an innovative tool that may work for some projects and may not for others, but generally is a tool available to address the growing funding gap in all sectors, whether it's water and sewer and stormwater, whether it's transportation infrastructure, so-called social infrastructure, as is the case in courthouses or libraries, or other types of building and public civic buildings. Now, most states, as I'm sure you're all aware, require public awarding authorities to award construction contracts to the responsible bidder offering to deliver the project at the lowest price using design, bid, build delivery methods. And that's where a public entity enters into separate contracts with the designer and the contractor. Very traditional, what's been the case for some time in most jurisdictions throughout the country. Rhode Island law requires such contracts to be competitively bid, but expand upon the evaluative criteria as we will discuss today, so that price alone isn't the sole determinant in selecting and awarding a construction contract. But Rhode Island is unique in that regard, in that they do have expanded upon the low bid specific centric awarding and selecting of a contractor, but do not at the same time have express public-private partnership statutory framework in place on the books. Currently, 38 states, the Commonwealth of Puerto Rico, and the District of Columbia have enacted express P3 legislation granting public awarding authorities the ability to use public-private partnerships as a project delivery, and project finance tool, in addition to traditional design, bid, build, delivery. These statutes all vary in terms of scope, the types of participants, the project sectors, and so on. In New England, Rhode Island and Vermont are the only states that do not have P3 legislation on the books. Connecticut, Massachusetts, Maine, and most recently New Hampshire have enacted P3 authority. However, all of those states grant such authority only to state actors and only toward transportation construction. So in the case of Massachusetts, for example, there's been express P3 authority in the books granting MassDOT the ability to use P3 since 2009. They haven't utilized that program to date. A good friend of mine serves as the chairman, the current chairman under Charlie Baker, the governor of the Commonwealth of Massachusetts, as chairman of the P3 Oversight Commission, and they're hoping to jumpstart that program. But that authority has been in place for some time and has not been utilized. Same thing in Connecticut. They have a pilot program that they keep having to extend it. To date, Connecticut hasn't used that program. But like I said, Maine and New Hampshire has very recently enacted legislation this past year, and there's an expectation that there'd be some projects that are born out of that in the very near future. But again, Vermont and Rhode Island are the only states in New England that do not have express P3 authority. And then in many other jurisdictions, as I said, there's 38 plus the District of Columbia and Puerto Rico who have P3 authority. They're very expansive, as was cited to by the gentleman before me. Virginia, Texas, California, Kentucky most recently. I was out in Kentucky speaking on this subject on behalf of the National Council of Public-Private Partnerships. They have very robust legislation. But all these bills are very much broader than what we've seen in New England to date and have included other types of infrastructure aside from transportation and other sectors like water and sewer and stormwater and social infrastructure, as well as grant not only state agencies the ability to use these methodologies, but also counties and municipalities. So very expansive legislation that we've seen enacted across the country. And as you, I'm sure, are all aware, in Rhode Island, back in May of 2015, similar legislation was introduced and was submitted to House Finance, and that's as far as it had gotten at that point, which was House Bill 6250. And so, again, while we don't have any express P3 authority in place to date here in Rhode Island, the state's legal structure does allow for the use of P3 to varying extents, and depending also on whether you're a state entity or municipality, for several reasons which I'll get into today. In fact, Cranston, Rhode Island was the first of its kind P3 in the wastewater sector, did a concession well over 20 or 25, 30 years ago. So in Rhode Island, there is a framework that does provide for these, what some may say, innovative structures, and have been used for decades, as the chairman had indicated earlier. So let's go through the legal framework here in Rhode Island more specifically. First, the State Purchasing Act and the Municipal Purchasing Act give rise to this analysis. So I would, of course, divert your attention to Rhode Island General Laws Section 37.2 and 45.55, respectively. The low bid statute applicable to both state and local entities provide that any public construction contract in excess of $10,000 must be awarded to the responsive and responsible bidder whose bid is either the lowest price, the lowest evaluated, or the responsive bid price after conducting competitive sealed bidding. If you're going to premise the award of the contract on the responsive bid price, you have to utilize objective measurable criteria. Certain independent authorities, such as the Narragansett Bay Commission, provide similarly in their procurement regulations. Although they're not required to abide by the State Purchasing Act, they do in spirit. And in the case of NBC, for example, their procurement regulations do provide similarly. And some independent agencies strictly adhere to the State Purchasing Act, for example, the Rhode Island Airport Corporation. The Rhode Island Superior Court has long interpreted the low bid statute to, quote, not preclude an awarding authority from taking into account factors beyond price, end quote, and that awarding authorities are, quote, not necessarily required to award the contract to the responsible bidder who minimally satisfies the criteria in the RFP and submits the lowest price, end quote. That line of cases goes back to the early 70s and was most recently affirmed in decisions in the late 90s. Moreover, the courts have held that in determining the lowest evaluated bid using objective criteria, remember I said you have to use objective criteria if you're going to use award on the basis of a responsive bid price. But if you're using objective criteria, an awarding authority need not to reduce to a dollar amount any such criteria in the invitation for bids. Instead, the awarding authority, state or local, may exercise reasonable good faith discretion without having to unqualifiedly award the contract to the lowest bid. As such, price alone is not the sole determinant in awarding a public works construction project in the state of Rhode Island, a stick construction project in the state of Rhode Island, or any public construction in the state of Rhode Island, under either the state or the municipal low bid statutes. They're both written very similarly, almost mirror one another in this regard. So first, that's the first step. Second is the competitive negotiation statutes contained again in both the State Purchasing Act and the Municipal Purchasing Act. Government entities are permitted to enter into contracts through competitive negotiation when the purchasing agent, as the case may be, determines that the use of such competitive sealed bidding under the statute I just cited to is not practicable in accordance with regulations issued by the Director of Administration for state agencies, or in the case of cities and towns, by the City or Town Council. And that's Rhode Island General Law, Section 37219 in the case of state, Rhode Island General Law 4555-6 in the case of municipalities. Again, state agencies and municipalities may enter into negotiations with two or more proposers and award contracts to the responsible offerer whose proposals determined in writing to be the most advantageous to the awarding authority, taking into consider price and evaluation factors. So again, not just price alone. So same thing as in the low bid context, now in the competitive negotiation context. Similarly, a contract does not have to be awarded solely on price. And again, certain independent authorities, I mentioned NBC and the Airport Corporation here in Rhode Island, both provide similarly. So again, price alone, not the sole determinant. Thirdly, professional service contracts. Again, the State Purchasing Act and the Municipal Purchasing Act are similar in this regard, in that architectural, engineering, or other consultative services entered into through negotiated contracts are based on demonstrated experience, qualifications, and competence, and at fair and reasonable prices. In the case of municipalities, they must use qualifications-based selection. So again, price alone is not the sole factor in making a decision to award a contract for professional services. So both in the construction context and now in the architectural, engineering, and other consultative services sectors. Now, the State Purchasing Act, unlike the Municipal Purchasing Act, does provide for provisions, or expressly includes in the statutory framework, language that allows the state's Director of Administration to promulgate regulations allowing state agencies to use alternative delivery methods. Now, the Municipal Purchasing Act does not provide that express language, but in the case of the State Purchasing Act, applicable state agencies, the Director of Administration has the sole authority to promulgate regulations authorizing such alternative delivery methods. So some of the things we talked about at earlier meetings: design, build, long-term contracts, operations and maintenance, DBO, DBOF, and so on. Now, in the case of Rhode Island's regulations, there is a finite group. So design, build, and OPM are specifically authorized under the state's regulations. So not a full gamut of what, some of the other things we've discussed in prior meetings. Similarly, independent authorities such as the Narragansett Bay Commission, for example, permit the use of certain alternative delivery methods such as design build pursuant to their regulations. Others, such as the Rhode Island Airport Corporation, do not. And the Airport Corporation's regulations, I think, date back to the earlier mid-90s, so a little bit before a lot of these more innovative approaches were more widely used. State law also expressly permits state agencies to use construction manager at risk, CMAR for short. Again, an alphabet soup is what the topic is. CMAR for building projects that cost no less than $5 million. And that's State Procurement Act Site Section 37227, and in the case, 32227 through 37227.5. That law was most recently amended in 2014. It wasn't originally structured, but in 2014 the Act was amended to exclude, quote, highway or heavy construction projects from the provisions of CMAR. So those types of projects, although that definition is not clearly defined in the statutes, those types of projects are not or expressly excluded from the provisions of the CMAR provisions under the State Act. As far as the state's concerned, there is a limitation that just wanted to briefly touch on. The statutes, the State Purchasing Act again, specifically prohibit certain types of contracts, cost plus a percentage of cost contract. That's specifically prohibited under state law here in Rhode Island. State agencies can only enter into GMP, guaranteed maximum pricing contracts, plus a fixed fee, which is normally referred to as a cost reimbursement contract, and only in the event the contract is determined to be the least costly to the state, or that it's impractical to use another type of contract. So there is a limitation, express limitation, on the types of contracts that a state agency at least can enter into. That same prohibition is not found in the Municipal Purchasing Act, however. So switching gears to the municipal level, there is no express authority, as I may have alluded to earlier, like in the case of the state, in that the state can promulgate the use of alternative delivery methods. But because of the analysis that I went through with regard to the low bid statute, the competitive negotiation statute, as well as the professional services procurement statute, municipalities have widely used P3s to varying degrees across the state of Rhode Island under that analysis. Most recently, the Rhode Island Superior Court determined that the municipal low bid statute is inapplicable to concession agreements. This was last year. The court, in its reasoning, held that the low bid statute was meant to regulate the expenditure of public funds, not a contract producing revenue. And since the municipal and state agency low bid laws are nearly identical in this regard, it seems reasonable to conclude that the courts would arrive at a very similar conclusion in analyzing the state low bid law. So, with this in mind, it seems reasonable to conclude that concession-style agreements, such as a DBOF arrangement, as was discussed at the last meeting, is allowable and authorized if you look closely at the court's reasoning in that recent case. So again, in wrapping up, if you look at the low bid statute, the competitive negotiation statute, the professional services statute, all of which price alone is not a sole determinant in awarding a contract, there is an argument of authority in interpreting those provisions, coupled with the fact that state law does expressly allow for the use of alternative procurement pursuant to the regulations issued by the Director of Administration, the fact that the courts have recently upheld concession-style arrangements, finding that the low-bid laws are inapplicable to those statutes, it seems reasonable to conclude that there is authority, but authority without express authority, as in what other states have done, the vast majority of them, which is setting forth a strict framework in their state laws. One other thing that I did want to just point out, and I'm sure all of you have read this, almost as inescapable as you watch any of the 24/7 news cycles, is President-elect Trump has focused his energy on infrastructure investment as part of his immediate domestic agenda. His infrastructure plan appears geared to avoid traditional tax-based financing and governmental bonding and attracting private equity money to build public infrastructure. He's proposed a $1 trillion P3 type of program. Now, some of that is driven by tax incentives. I believe I read somewhere that he's proposing to provide up to an 82% tax break for private companies to invest in public infrastructure, which could, that tax break alone could be almost $200 billion. But a $1 trillion P3-based program that, again, is encouraging private equity investment. And one way to do that is what he's proposing on the tax side. The other is a tax credit. The other is looking at a return on investment made up front, as a P3 may provide. As we heard last meeting from participants in the program, the decision to make an investment and avail themselves of these is driven a lot by state policy. And without it, there may be a disincentive for private participants in availing themselves of these types of programs, or what may be rolled out in the near future under a President Trump. But it's something worth considering, as over 3/4 of the states in the nation have done as part of your deliberations. So with that, I conclude and turn it back to you, Mr. Chairman.
Thank you, Matt. Any questions from the members of the panel? Matt, when you reference there's no explicit authority, could I interpret that to mean there's no comprehensive statute describing the process, procedures, standards for evaluating, first determining whether a project is susceptible to a P3 approach, and secondly, through running the procurement and awarding the contract for that delivery method? Is that
That's correct. And
otherwise, it sounds to me like you've clearly found authority. A lot of it is based on some limited language in these various statutes that you cite, and also the gloss added by the state courts in reviewing maybe contests to certain challenges, if you will, to certain awards of contracts.
And that's correct. And in many of the other jurisdictions I cited to that do have express P3 authority, statutes, differ in many respects, but a common thread among them is a prescribed process, certain IFB requirements, certain contracting requirements, basically a roadmap in legislative form. They do vary. They do vary in terms of a whole host of issues, but those are common threads that I think may be helpful here in Rhode Island and in other jurisdictions that are looking at this for the first time. But that's true.
Brzezowski?
Matt, thank you for all the information. The folks that were at our last meeting described projects that were seemingly $1 billion and up. What have you seen in nearby Mass or Connecticut in terms of range of projects that have been successfully done through 3P agreements?
Great question, and thank you. So in Massachusetts, sure, there are the mega projects. Some were cited too by the prior speaker. But on the municipal level, Massachusetts is different in that we require design, build, lowest price under Chapter 30 of our general laws and Chapter 149 of our general laws, horizontal and vertical construction respectively. So it requires, in the case of a municipality, a home rule petition and a special act of the legislature. And to date, hearkening back to, I want to say, the late 80s in the case of Springfield, well over a dozen cities and towns, some as small as Lee and Provincetown, Massachusetts, have sought similar authority and have been granted such authority almost on a rubber stamp basis. And in fact, because of that reason, we have been pushing legislation in Massachusetts on the water sector to promote the use of alternative delivery methods outside of Chapter 30 and 149 of our general laws for some time, and it's gaining a lot of traction, which does not surprise me since we have a $50 billion or so funding gap in that sector, and that's a municipal controlled sector. So, but in Massachusetts, the neighbor to the north, it has been done on smaller projects, you know, more innovative project delivery systems aside from design, bid, build, that is.
Mr. Bernardo.
Matt, real great information. If the authority exists now, and we've been doing it for 25 years, what is the biggest detraction? Are we less competitive because we don't have the same legislation that Massachusetts and some of these other states have? You know, I'm trying to identify the disconnect. If we've been doing it for 25 years and the authority already exists, it doesn't sound like we're less competitive. It sounds like we're doing it anyway. What do you think?
I've got some views and experience in Rhode Island.
I'll just say that, you know, we did hear, for example, last meeting from Meridian, who's a financial investor consultant group that looks at this and makes these determinations on behalf of the Skonskas and the Gilbanes and others who participate in this area. You know, clearly it sounded to me there was somewhat of a disincentive not having some sort of clear framework. But clearly, Rhode Island's an anomaly of sorts nationwide, which is good or for better or for worse. But, you know, in that we do have a framework that allows it to varying degrees without that express structure in place. I can't really speak to what the industry would say, but I think based on what I've heard over the years at various events and forums and conversations like this that have been had, that there's definitely an incentive to have something on the books that provides a structure, to provide some level of certainty, but without, you know, an analysis I had to just outline to you in place.
If I could expand on Matt's remarks, again, I've kind of experienced or lived the history of P3s in Rhode Island to a large degree, and it was, again, I came out of an environmental agency into private practice. A good many years later, found myself working for a community that needed to upgrade a wastewater treatment plant significantly, using fairly sophisticated technology to treat to ever-lessening levels of contamination. And it's very hard to compete as a municipality for that kind of talent. We looked to the most recent facility that had been done in the city of Cranston, a markedly different agreement and approach than the one we took, but nonetheless a P3. But beginning with Woonsocket, later with Pawtucket for their water system, East Providence wastewater system, Newport also went through this kind of a process. What we developed essentially, in the absence of a real framework, roadmap, delineation of standards in statute for doing these P3s, we developed that. And with each iteration, it became a better document in terms of protecting the public, ascribing risk appropriately, you know, assuring that costs were maintained. And again, there's one particular municipal leader who believes that we probably saved 35% in the overall cost of building, operating, financing, and again, the employee cost, all-in costs, versus what they could do as a typical design bid build. But that's in the water and wastewater area. We haven't had much experience going beyond that. And I think the vendor community, the big companies, which are almost all international companies, which lead the teams that bid on these projects, relying for construction on, on local contractors, and also utilizing employees in accordance with what we developed was a method of doing impact arbitration, impact negotiation with the local municipal union prior to the P3 even being issued, so that the bidders knew what standards they had to meet with respect to employees. All of that we pretty much developed on our own. So that's in place, and I think the business community, the major companies who bid on these projects, are now used to it. They know what to expect when they come to Rhode Island. I don't know that's the case in the transportation area or any other areas. So they look for guidance to these comprehensive statutes that provide more detail in terms of process, standards for review, when's a P3 is appropriate, how it will be approved and ultimately implemented. And I think that's what they see as lacking. That's what I heard in the presentations last.
Yeah, and by no means were my comments to promote one way or another, because I think we're all toying with that currently, but it's definitely something that's out there as an issue that I've at least heard that needs to be at least considered.
I mean, one of the decisions or recommendations, it's really not our decision, that we need to kind of come to make to the General Assembly is what if anything, do we need to supplement the current authority for P3s? Do we need a fully comprehensive statute? Is that the best way to go? Or do we need to fill a few of the holes that currently exist in current legislation, such as protection for unsolicited proposals, so at least the intellectual property associated with somebody's idea on how to better provide government services or better deliver a government facility is protected in what ultimately has to be a bidding process? Or do we do nothing at all? I mean, that's really what it comes down to. And again, it's been in my case, a 20-year journey to come to a point where, we can deliver these water and wastewater projects utilizing private industry, often led by these major international companies. But do we want to go through that's kind of same 20-year odyssey in trying to fashion something that works in the Rhode Island context in other areas, such as, be it transportation or education? We've worked on some education projects too. You may hear about those next month, where we've delivered projects in very unique circumstances. But again, there's no roadmap. So I think what's happening, what we were being told last week was that those industries that are interested in delivering projects in other areas just don't know the rules of the road in Rhode Island. And in water and wastewater, the currently outgoing EPA Region 1 administrator will tell you that our sewer plants, proportionally, given the size of our state, are in much better shape than Massachusetts, because we've had that vehicle. We're fortunate to have Providence Water delivering water to 60% of the state, but Woonsocket, Pawtucket now have first-rate water systems that have been upgraded to meet current requirements, to protect public health. Again, much better situation than many other parts of the country. I'd love to see us do the same with, other areas where where public services or public projects are required. And again, as Matt indicated at the beginning, the public doesn't give up ownership of these facilities, and clearly public funds are always going to be expended getting these projects done, whether you do them in the traditional method or not. But what we've found is that the private sector can add a good level of efficiency, and not at the cost of anyone or to anyone, including employees. If they're managed properly, and if the procurements are run with appropriate standards that protect all of the state's interests, it can be structured in a way that it does work. This is not something you do kind of off the cuff, on a wing and a prayer. And again, I can tell you how much time and effort it took to come up with an agreement that dealt with all of these issues and concerns on the public level, protected the public interest as much as possible in these water and wastewater projects. But again, we may want to consider some framework. And the prior speaker, I think, alluded to some of the other concerns that many of the concerns that do exist, and the perceptions that can be caused by doing P3s poorly. Anything can be done poorly.
Well, I think also
our job to assure we have a, whatever legislative approach the General Assembly ultimately decides to take, that we help assist them in a way that, again, promotes the public interest as much as possible.
Yeah, and I think the upfront process, the analysis, the financial analysis that's conducted way up front before you even embark down this road is so critically important. What's known as a value for money analysis that compares apples to apples, what traditional delivery and what alternative structures are out there, what that cost value is. And that's a sophisticated analysis that involves your technical consultants, your financial advisors, specialized financial advisors, your legal counsel, etc. And that's where you make the determination. As was discussed in prior commentary, it's not a one-size-fits-all solution, and P3s, for that matter, aren't, just like DBBs aren't. So it's really, that's why it's so important to avoid some of those financial issues that may have arisen in some of those limited other projects.
And one other quick comment I'll add, and then I'll stop talking. With respect to financing these projects, I mean, that's been a challenge of late. I mean, even in the wastewater area, there's a lot of competition for the available public debt that's dedicated to upgrading wastewater treatment plants, building new water plants, and now dealing with stormwater controls is going to be even more demand. The state only has so much capacity. I think Mr. Simmons would agree with that in terms of its debt, and they only should go so far. Relying to a degree on, private funding, which is available for these kinds of projects, particularly where there's some, user fee base that can be used to secure the financing, is an attractive alternative, without kind of overloading the public balance sheet and debt.
And just to piggyback on that, I'm not sure if it came up at prior meetings, but the United States Environmental Protection Agency supports the use of community-based public-private partnerships to deliver stormwater projects, and have done so very well in Region 3, particularly in Maryland, Prince George's County. And I would strongly encourage you to, if you Google community-based PPP, EPA, they put together a great guidebook that I think could be a useful resource that's readily available on the internet.
Yes.
When they're doing the
Scanlon.
wastewater treatment plant, what's the source of revenue to pay for the P3 services?
In many cases, it's a user fee.
But it's stormwater. It's flowing off the roads. How do you assess a user fee?
Many communities, I can address that, I think I can as well, but many communities do essentially, hate to say it, but in many cases it'll be labeled a rain tax, and essentially it's based upon the square footage of property that's that can't absorb hard surface, that can't absorb water. And there are methods of providing credit if you create a roof garden, if you have vegetated areas on your property that's not hard surfaced, your fee is going to be lower. But believe it or not, one Rhode Island-based company is doing a retrofit of the entirety of Prince George's County, Maryland. It could amount to as much as 10,000 acres adjacent to the Chesapeake Bay, which is a very sensitive ecology associated with it. Also happens to be close enough to Washington, D.C., where it's kind of a lab for EPA headquarters.
No, I mean,
we'll see where this goes, but
the reason I ask is Rhode Island is embarking on a major stormwater project because of consent decree with the EPA. And if the answer is to raise property taxes based on the square footage of your lot to pay for it, good luck.
Won't be property taxes. It'll be a separate fee. Some communities have opened up a separate district. And Mr. Bernardo's department is entered into a consent decree to essentially retrofit, I don't know how many miles of the state highway system that has older drainage systems that were primarily designed to deal with flow as opposed to water quality. So there are all of these issues out there, and frankly, there's only, so much talent available to kind of address it. That's been my finding in the environmental area, where I have more experience. But
No, I just see where you get into these public projects. Clearly, the cost of private capital is substantially higher than the cost of a municipality borrowing on their own.
not recently.
Well, from the state level, it would be.
The
So you're paying additional cost of capital just to buy expertise that you don't have? Is that what you're doing?
Well, no money's free money, whether it's public or private. And I think, as I was discussing earlier, vis-a-vis the federal plan that's being cobbled together as we speak, they're looking at a hybrid of different creatures, tax credits and the like. But, somehow incentivizing that influx of equity capital in particular is critically fundamental to supporting these programs, and incentivizing that however way we can, whether it's through P3s or some other mechanism, should be looked at.
Richard? Mr. Bernardo?
Yeah, my understanding of what New York was doing with the Yonkers models for the schools were there was a very low interest rate for the borrowing of the money. It came from a lot of union pension funds that wanted a secured set return on their investment, similar to the bond market. So it's not always necessarily more expensive to do the P3 because there is large groups of money with large entities with money that they want to invest and get a consistent rate of return, not play the market and run the risk of losing money.
Oh, at our last meeting, one of the speakers mentioned that that's their source of financing is union pension funds.
I mean, there is a lot of money available in these funds. It's looking for more or less secure investments that have a cash flow associated with it, often from user fees. And it ultimately, again, the capacity of the state or municipalities is only so great. If you're dealing with a distressed community that has a B whatever minus bond rating, is it better to try to work through an agency such as the Infrastructure Bank that has a AAA rating, and then outplace that financing privately so that it doesn't essentially further burden the debt profile of that community? That's often how it works, but it relies to a great degree on private equity that's available out there.
And keep in mind that, a GO bond is supported by, the taxpayers. That's secured by the property tax. In the case of a revenue bond, it's supported by the revenues generated by the project. In the case of some of these P3 structures, similarly to the end users of those facilities, whether it's a toll road or, the end user on the water plant.
So I don't, the background of this, I don't know if I'm on or off. The background of this is, we've had kind of mixed success delivering projects, for quite some time. And certainly even less success in maintaining those projects over the long term. So again, assuming that you can anywhere near replicate some of the experience in communities that have dealt with water or wastewater on what they feel they've saved in doing a P3 type procurement, that goes a long way to offsetting whatever small differential there might be in the debt service associated with it. And again, you can get these projects out and underway much more quickly. At least that's what I've seen. A lot of projects where I've ultimately recommended or been involved, where the recommendation has been made to approach it as a P3, were floundering for years before the P3 approach came up, particularly in the water and wastewater area. I mean, plants that were on the verge of collapse or developing real problems.
Can I direct a question to one of our other panelists here?
Please.
How is the state going to pay for the 4 projects that they have out there today for proposals for P3s? The train station, they've already got the proposals accepted. The gantries, they've got the proposals. The rest area on I-95. If we need statutes, how are they proceeding without them?
That question is probably better for the director, and I think the director is planning on coming in next month. But as Matt has said, the authority already exists. So it's not a matter of waiting for authority. The authority already exists. We can.
Then why are we here if they can already do them?
For the same reasons that Sean was just explaining, we don't have enabling legislation, and that's why I was asking the question of Matt. I was taking the same tactic because I knew that this was on your mind. If we've been doing it and we have the authority, what are we lacking? That's basically what it comes down to. That's our charge. The last people who, if I listened to Matt correctly, and Matt, correct me if I'm wrong, last month when we talked to experts in the field, there is a, whether it's real or perceived, a disadvantage in the state of Rhode Island. We may be less competitive, and that's up to us to decide if it's real or not, to make our recommendation to the legislature, whether or not the legislation is fine, whether the rules are fine the way they are, whether they need to be tweaked, or whether we need to promulgate full legislation. That's our charge. We're trying to go through that. We know we have authority. We know we're doing these projects. We're listening to the industry, part of the industry, and again, it may have been self-serving, and that's where we have to figure it out, saying we're not as competitive as other states because we don't have the legislation in place that promulgates the regulations for at least the rules on alternative technical concepts, protection of unsolicited bids. That's the way I see this evolving. That's the way I see the need for this committee and our charge to figure out, is it a tweak? Is it leave it alone because we are doing it? Or is it full legislation that's needed? I don't have the answer to that yet, but that's what I'm trying to work through.
Oh, essentially an enabling legislation guidebook.
A roadmap, exactly. You know, that was what comprehensive legislation would provide, if that's what we want. I mean, again, Rhode Island needs to decide, and this commission, I hope, will come to a recommendation as to what at least what the benefits are of any action that we take. Do nothing, provide some gap measures to fill in any gaps that exist in the current authority, or alternatively do a full comprehensive.
Well, Matt, as you work in all the other states, do you have a list of what we're missing that we should add?
Yeah, and there's some model legislation that's out there that various organizations have used. You know, I was the water P3 legislation I referred to earlier in Massachusetts. I helped author using language found in other jurisdictions, and like I said, there's a lot of common threads as well. You know, as far as, of course, you have to have your exemption language to the extent required pursuant to any state-specific legislation, but you also need to consider, you know, what type of process, you know, most, you know, in all legislation, you have at least an RFP stage. Do you want to include a two-step process or require that, an RFQ, RFP stage? What's in the IFB? What are the contents? What are the evaluative criteria? You know, what do the contracts themselves have to include? What's discretionary? You know, private financing language, expressly authorizing such, how that interplays with federal financing. There's a whole host of areas that are, again, common threads throughout many of these various jurisdictions, legislative enabling legislation, that, you know, could serve as a model if that's of interest to the commission to look at. So there are various structures out there that could serve as a model of sorts.
You know, while we've kind of invented the wheel ourselves for water wastewater projects, I mean, the other states and jurisdictions have kind of gone ahead and taken the more comprehensive approach. You know, we may not agree with the contents of all of those. There may be some improvements to be made on that. There may be certainly some Rhode Island interest. You know, heard from the prior speaker about some areas of concern that, you know, I think are we need to keep in mind and give attention to at the same time. So there's various approaches that we can take, but the more we can make this procurement process predictable, transparent, understandable, not only by industries but by those who live in the communities or live in the state who are going to rely on this process, I think the better off we'll be. I mean, I didn't mind the opportunity over the last 20 years to kind of invent the wheel on water, wastewater, but I'm not sure I've got enough time left to do it again for something else, but is there a better approach? I think that's really what we know. Because I think it's clear that in many sectors of the kind of services that are provided to the state, it hasn't been entirely adequate, particularly with respect to maintenance of many of these facilities. And that's one area where P3s can be particularly helpful. Any other questions of Matt or anyone else? Any other comments from those of you who've sat patiently through all of this at this point? In terms of our plans from here, again, we'll have another meeting early, mid next month, January that is, and at that time we'll invite, again, state agencies, municipal agencies to participate and give us their views and experiences with P3 procurement approaches, and also identify what they feel their need is. And if there's nothing further, I'll solicit a motion to adjourn.
Adjourn.
All in favor?
Aye.
Thank you.